Humphrey versus Michael Humphrey.
For the record, this matter is before the court for the purpose of reviewing various post-judgment issues. This hearing is being conducted via Zoom. President Attorney James Petrangelo representing the plaintiff, Melissa Humphrey. Ms. Humphrey is present. In addition, we do have the defendant, Michael Humphrey, present. Good morning, everyone.
Morning.
Good morning, Your Honor.
Okay. The last court hearing on February 6, 2024, Mr. Humphrey did not appear. The court's pleased that he did appear this morning, and hopefully he's in a cooperative mood so we can finalize these outstanding issues. Mr. Petrangelo, the court received, Mr. Humphrey emailed to my staff looks like a Form Quadro, I'm sorry, a Form EDRO for the Michigan Public Schools and Retirement System. It looks like it's a form issued by the administrator for the Michigan Public Schools Employees Retirement System, but obviously it's not signed. I don't know if you have a copy of that.
I do not, Your Honor, and I've explained, and Mr. Humphrey understands, we need to receive this. He's going to email me and Ms. Humphrey a copy of that so we can review it, make sure we're all in agreement with the language and that Ms. Pastrana is in agreement. She's assisting in this. So we agreed to move that along. Ms. Humphrey went ahead and paid 100% of the cost of that quadro or EDRO. Mr. Humphrey's entitled to a share of Mrs. Humphrey's retirement plan as well. There's a cost to that. He'll have to pay that if he wants it. The parties are going to continue to discuss that prior to our next review hearing. I think we've made progress. I would tell the court Mr. Humphrey's caught up on the amounts he owed his ex-wife. Thus far, they filed the taxes. They still have some financial obligation to work out there they want to discuss. We need some verification that Capital One payments have been properly applied and to clarify the amount still due. Mr. Humphreys agreed to an additional attorney fee of $225 in addition to the $800 previously ordered to resolve that issue. And we are asking for a review hearing so that they can be sure this EDRO gets properly processed and these remaining items are either paid or we have a set payment plan they're all agreeing to.
Thank you. The court has received a written recommendation from Ms. Mayville from front of the court, which I will read into the record and share with everyone. The recommendation, if adopted, will come over to the court. The recommendation is that the defendant, Mr. Humphrey, will cooperate with the completion of the Quadro qualified administration's order for his accounts. Mr. Humphrey shall be responsible for the financial costs of filing a Quadro on plaintiff Melissa's retirement accounts. Further, the defendant, Mr. Humphrey, shall provide documentation and bill summaries that proves that the Capital One is being paid off, and the closure of said card will be proven at the end. Further, Mr. Humphrey agrees to pay an additional $225 attorney fees to Attorney Petrangelo. And finally, the parties appear back for his court for what's hopefully a final review, May 22nd, 2024 at 2 p.m. to monitor payments, completion of the Quadros, continued payments, and any other outstanding issues. And Mr. Petrangelo, is this recommendation agreeable with your client this morning?
It is, Your Honor.
Thank you. Mr. Humphrey, good morning. Do you understand the recommendation?
Yes.
Do you have any objection to the court adopting this recommendation?
No, not at all.
Right. Let me make sure that Mr. Petrangelo in the front of the court has your mailing address so that you can be mailed copies of these orders, Mr. Humphrey. Can you state on the record what your current mailing address is, please? That's the address we had for you. Anything further than for the record this morning, Mr. Petrangelo? Do you wish to guard there? Ms. Humphrey, is it necessary?
No, that's not necessary today, Your Honor.
Mr. Humphrey, do you have any questions for the court?
No, I think we're okay. Mr. Petrangelo helped me out throughout the meeting.
Okay, so keep contact with Mr. Petrangelo if you have any questions, concerns. So let's try to get this done so we come back on May 22nd and say, hey, things are done. You move forward.
Okay.
So, note in your calendar, May 22nd, 2 p.m. will be a Zoom hearing, Mr. Humphrey. Now, what's with your schedule? Correct that date and time?
Yes, I have it written down.
Okay. All right. Nothing further. Call a doctor recommendation. Thank you, Ms. Mayville, for your assistance this morning. Now we'll conclude this matter. Everyone can zoom out after the rest of the day.
Thank you, Your Honor.
You're welcome.
Michelle Jones versus David Lichtner.
For the record, this matter is before the court on the objections filed by the plaintiff, Michelle Jones, to a referee recommended order of child support and parenting time. This hearing is being conducted via Zoom. It appears both parties are present, Michelle Jones and David Lichtner. Good morning, both of you.
Good morning.
Morning.
Good morning, Ms. Brower.
Your Honor.
The two of you have conferred with Ms. Brower for the front of the court this morning. Ms. Brower has provided the court with fine recommendation. The recommendation is that referee recommended order be adopted but modified as follows. Namely, fathers should have 2 phone or video phone calls per week. The days and times are to be agreed upon by the parties. In addition, fathers should have 1 weekly visit at Family Counseling Shelter Services. I will tell you right now that there's about a 6-week delay in backlog. So both you need to call an agency. We'll provide you with their phone number to schedule an intake. And then as soon as they're having availability, they will call to make arrangements for that. So we can reestablish a relationship between dad and a minor child. So once a week, Family Counseling Shelters, once they're available, that's going to say at least 6 weeks. The circuit court fund will pay for the intakes and the visits. Two of you, upon receipt of this order, shall immediately contact the agency to schedule the intakes. With respect to child support, it's recommended that the child support recommendation with an effective date of December 1st, 2023 is adopted. The child support shall be referred again to the front of the court for further investigation with effective date of May 1st, 2024. The parties' 2024 income shall be used for calculations. Finally, the parties will occur back for its court to review parenting time on June 11th, 2024 at 8:30 a.m. via Zoom. That is the recommendation. Ms. Jones, do you understand the recommendation?
Yes,
And are you agreeable with this recommendation this morning?
I agree.
Mr. Lichtner, do you understand the recommendation?
Yes, sir.
And do you have any objection to the court adopting this recommendation?
I'm having a hard time hearing you, sir. Can you say that again?
Are you agreeable with this recommendation?
Yes, sir.
Do either of you have any questions for the court?
No.
Not at this time.
Okay, so who's going to initiate? The two of you will text each other, agree upon the time of the days that's good for Connor for these. And obviously, it's got to be appropriate discussion, Mr. Lichtner. Obviously, it's not going to be, he's not going to want to talk for 15, 20 minutes or 30 minutes. It could be just 5-10 minutes. It may get longer as you develop a relationship with him. But just find out how he's doing, how's school doing, and keep it light and comfortable for Connor.
I try to, sir.
And the other thing is, you may need to secure employment the 4 months of the year that you're off from roofing. And you can't expect the rest of your life just to collect unemployment for 4 months a year and only work 8 months.
Sir, I can do what I can do. If I'm working, that's all that matters. And if I'm not working, I collect unemployment.
Well, I'm just saying, but again, you're
Yeah, I know.
able. If you're
I
a
get it.
roofer, you're physically able-bodied. There's no reason there are employers out there that are screaming for employees. There's no reason why you can't find employment during those other 4 months. Because the court.
So
may-
are you
may-
saying my work is not
if you're
suitable
capable of
then,
employment
or?
and you choose not to be employed, the court may impute additional income to you because you're capable of doing better than unemployment. I'm just letting you know that. So come back for the court. That's an issue with this court.
All right, sir, sure.
All right. Ms. Brower, anything further?
Not at this time, Your Honor.
So if I understand it correctly, that the child support recommendation of $230 a month, that will be effective December 1st. But then we're going to again review child support, and any modification will be effective May 1st, correct?
Yes, Your Honor.
All right. All right, so both parties having agreed, the court will adopt the recommendation. We'll see everyone back on June 11th at 8:30.
Sounds good.
All right, that'll conclude this. You can both zoom out. Have a good rest of the day.
Thank you. I appreciate it.
Bye, Michelle.
Okay, thank you.
I'll call you.
Bye.
Barbie, representing the plaintiff, Randy Brewer. Ms. Brewer will be present with Mr. Barbie. In addition, Attorney Charles Abel is present, representing the defendant, Father John Cummings III. Mr. Cummings is present. Good morning, everyone.
Good morning.
Morning, Your Honor.
Morning, Judge.
We were last before the court on February 9th. The parties agreed that they should share jointly custody of the minor child of the parties. And the primary issue with that of parenting time. And the court overheard that the parties were unable to reach their own agreement. Is that correct?
That is correct, Your Honor.
The only thing I would note, Judge, is that the primary issue is not parenting time. The primary issue is the income between the parties and the associated support. They have an established parenting time schedule that they've been utilizing for over a year now.
Well, and Your Honor, we would dispute that parenting time is settled also.
What?
The parties obviously there's not been any motions filed. Obviously, the parties have been practicing or exercising a schedule for some period of time, but that needs to be modified. Is that correct, Mr. Barbie?
Yes, there are some issues that possibly be presented at trial that may need to be modified.
All right. The court's initial instinct is want to refer the issues of custody of parenting time and child support to the front court for formal investigation recommendation. The front court can get tax returns, recent tax returns and pay stubs from the parties, and issue a written recommendation. Each side would have 21 days in which to object to any recommendation. If so, then it'll come before the court. At least the front court can do that investigation. They could also interview both parties, make a recommendation at the parenting time, and come back and argue those matters. Does that make sense?
Yes, Your Honor.
I have no objection, Judge.
Do we need right now, is there any support being paid?
There is.
Yes. Between $142 and I think he paid $224, some nominal support being paid right now.
Do you want to talk with the front of the court this morning? The front of the court can make a recommendation based upon verbal representation as the income. At least we could get a formal order of child support effective immediately, and then still refer that issue for further investigation. If in fact Ms. Brewer needs some financial assistance and the amount being paid is not acceptable, Mr. Barbie, do you want to talk to the front of the court this morning?
Your Honor, unfortunately, it's quite complicated with Mr. Ebel referenced. We've got some discovery and outstanding, not due yet. It's due in about, 15 days or so. We have some discovery we've provided. My client's got to provide the rest of it today. I don't think the front of the court right now, just with talking to them, this goes back several years and there's some allegations about income as to both parties. So I think we would need the discovery first before we could proceed with that.
Okay. So if we don't, Mr. Ebel, I'm sorry to mispronounce your name. It's Ebel, not Abel. What about still referring the issue to the front of the court for formal investigation? It's not going to happen overnight. Do you want to start that process while you're engaged in discovery?
I would agree that we need responses to discovery before we can present it to the front of the court.
Okay. The court's going to put this matter back on its docket just to keep the matter moving until we get some orders entered. Do you want another review or status conference in maybe 30 days, 45 days?
Yeah, 45 days would be, I'm agreeable to that.
You think we'll have the discovery completed in 45 days?
It should be. I mean, I don't see why it wouldn't be. I don't know, Mr. Ebel.
I don't know that it will, Judge. The answers to defendants' interrogatories and requests for production of documents are now past due. I've only received bank statements. I don't know what I may receive today, but based upon what I received today, I do intend to depose the plaintiff. And I assume there will be items that are not produced that have been requested. I'm happy to have a review in 45 days. I just don't know if discovery will be completed by then.
Okay, 60 days then to review.
That's fine, Judge.
Have both parties filed their 2023 tax returns?
My client has filed, but is waiting on for them to be prepared. So I anticipate having those inside of a week.
Mr. Cummings has filed his and he's produced it.
Okay. All right, so we'll give we'll get some dates in about 60 days. Let's put them back in our motion docket.
60 days.
If you have your calendars, we'll suggest some potential dates and see if they work out with council.
I have Tuesday, June 4th at 8:30 or 2:30.
I can, I have a mediation that probably may go, it's scheduled, which is rare. It's an all day because it's a civil matter. So is there another date? I'm sorry, that date is just terrible for me.
I have Tuesday, June 11th at 9:30 or 1:30.
That's my anniversary week, and I am going to be in Florida.
Okay. What about the June 5th? Anything available on June 5th? Okay.
June 5th is fine if that's what you said, Your Honor, for me.
I'm just making inquiry.
June 5th at 2:15.
That works for me.
That works.
All right. All right, Court will mail out notice of a continued status conference June 5th at 2:15 p.m. With respect, and you're both asking the court delay ordering in front of the court to conduct a formal investigation. You want to complete discovery, and we'll just address everything on June 5th. Is that correct?
Yes.
Yes, Judge.
Okay. Do you need the court's assistance with respect to parenting time today? You need the court to enter an order, or are the two parties going to continue to work together?
My client said they'll continue to work together.
Mr. Cummings is willing to work together, Judge. I presented a proposed order regarding parenting time very early on in this case. As I indicated.
And Your Honor, I'm going to object to anything Mr. Ebel is saying right now. There is no settlement and there's no order.
It doesn't have to be a settlement. The parties have been working under an established custodial environment for over a year. So I don't know why this is not part of a court order.
Okay. The question is, do you want the court to make a temporary order this morning, or do you want the parties to continue to work together until June 5?
My client prefers to work together until June 5th.
I would like an order entered that the current parenting time schedule that's been in place be continued.
And Your Honor,
I don't know what that current parenting time schedule is. Mr. Barbie obviously would not agree with that without an evidentiary hearing. So at this point in time, if in fact, Mr. Ebel, it's not working, you can follow a motion with the court. But at this point in time, the court will review all these issues on June 5 at 2:15. Hopefully we'll have discovery completed. Hopefully the parties can at that time, if they cannot agree upon a parenting time schedule, the court can address it on June 5 to meet in front of the court. And he's got a temporary order entered pending an evidentiary hearing. But Mr. Cummings, Ms. Brewer, you know what's best for your minor child. You really don't want this court to tell you what your parenting time will be with your child? Think about that. You know what's best for your respective schedules and that of your child. So the two
I agree, Your Honor. I don't know what
work together.
I don't know what, this is all new. I don't know.
All right. Right. Anything further than this morning, Mr. Barbie?
I have nothing further, Your Honor.
Mr. Ebel?
No, Judge.
Okay, we'll send out mail notice to June 5 at 2:15 PM. All right, that concludes, everybody can all, thank you for your efforts this morning to zoom out and have a good rest of the day. Good afternoon. The court's pleased to be informed that the parties have entered into a consent order for joint legal, joint physical custody and equal parenting time, which is wonderful. Thank you, Mr. Barbie, for forwarding that copy of the court's information.
You're welcome, Your Honor.
The court has not seen the original. Maybe it's on the clerk's office right now, but in any event, I'm sure it's been mailed, so it'll be entered as soon as it's received. Ms. Brewer, Mr. Cummings, can you both please raise your right hand and be sworn, please?
I do.
Thank you. Mr. Barbie, if you want to begin with Ms. Brewer, just to confirm with her belief that this consent order is in the best interest of the minor child, please.
Yes. Hello, Brandy.
Hello.
So you had a chance to review the consent judgment for custody, parent time, and child support. Is that correct?
Yes.
And you had a chance to ask questions of me about anything that's contained in that judgment?
Yes.
And you did sign that judgment, correct?
Yes.
And as you heard Judge Braunlich state, the terms of the custody are joint legal, joint physical with equal parenting time. Is that correct?
Yes.
And do you feel that that is in the best interest of your minor child?
Yes.
Okay. And do you have would you like me to do the procedural elements too, Judge, or is that something you're going to do?
You can go ahead, Mr. Barbie, whatever your pleasure.
Okay. So, and then the child support that we figured that does follow the Michigan child support formula. That's correct, right?
Yes.
Okay. And when you filed this complaint for custody, was the minor child a resident of the County of Monroe?
Yes.
Okay. And was he resident, or was the minor child a resident for more than 180 days at the state of Michigan?
Yes.
And more than 10 days in the County of Monroe?
Yes.
And all the allegations you made in the complaint, were they true at the time you made them?
Yes.
Or do they remain true today?
Yes.
And you agree to be bound by the terms contained in this judgment, correct?
Yes.
With the understanding that child custody, parenting time, and child support is always under the jurisdiction and possible review of the court based on a significant change in circumstance.
Yes.
And do you understand you could have gone to trial in this matter?
Yes.
At trial, do you understand you could have done better, meaning different terms that you consider better, that you consider worse, or substantially the same? Do you understand that?
Yes.
But you're voluntarily foregoing that right to trial in the County of Monroe?
Yes.
And all the allegations you made in the complaint, were they true at the time you made them?
Yes.
Or do they remain true today?
Yes.
And you agree to be bound by the terms contained in this judgment, correct?
Yes.
With the understanding that child custody, parenting time, and child support is always under the jurisdiction and possible review of the court based on a significant change in circumstance.
Yes.
And do you understand you could have gone to trial in this matter?
Yes.
At trial, do you understand you could have done better, meaning different terms that you consider better, that you consider worse, or substantially the same? Do you understand that?
Yes.
But you're voluntarily foregoing that right to trial.
Yes.
And you would ask that the judge enter this judgment today. Is that correct?
Yes.
And you're doing so freely and voluntarily?
Yes.
No one forced you to sign this agreement?
No.
And again, this is in the best interest of your minor child.
Yes.
I have no further questions, Your Honor.
Thank you, Mr. Barbie. Mr. Miller, do you have any questions for Ms. Brewer?
Not of Miss Brewer.
Mr. Cummings, please.
Yes. John, did you read the judgment of divorce that was submitted to the court?
Yes.
And did you understand all the provisions in the judgment?
Yes.
And you signed the judgment?
Yes.
You signed this voluntarily?
Yep.
Do you think the provisions in the judgment are in your minor child's best interest?
Yes, I do.
Do you understand you could have went to trial where the results could have been better, worse, or the same?
Yes.
But you'd like the judge to approve the judgment that was submitted?
Yes.
Are you satisfied with the work of your attorneys?
Yes.
Do you have any questions of me or the court?
No.
That's all I have, Judge.
Thank you, Mr. Miller. Mr. Barbie, do you have any questions for Mr. Cummings?
I do not, Your Honor. Thank you.
Very well. The court would like to thank and acknowledge Mr. Barbie as well as Mr. Abel for their fine assistance in helping facilitate the amicable resolution. But the court would applaud you, Ms. Brewer, Mr. Cummings. It's wonderful. You can co-parent your daughter. She will benefit. She will thrive in life because you're on the same page. And without question, there'll be challenges in the future, but effective communication, you can address those challenges. So please keep an open mind, work together. Just the little things will mean a lot to your daughter. For example, make sure she gets a card for her dad for Father's Day. Dad, make sure she gets a card for her mother on Mother's Day. Just those little things mean a lot to children. But it's a great start. The court applauds you for reaching this own agreement. You know what's best for her better than anyone in this world. You don't want a stranger like the court making these kind of decisions. So the court finds this agreement to be in the best interest of the minor child, and the court will enter that order upon presentment, hopefully sometime this week. And that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you.
Thank you, Your Honor. You too.
You're welcome. Thank you. For the record, this matter is before the court on the defendant, Charles Straub's motion to vacate a divorce decree. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, along with her client, plaintiff Heather Straub. They're both present. Mr. Straub apparently has failed to appear this morning. He's not contacted the court. This matter was scheduled for 10:30. It's now 10:45 a.m. Court was quite confused as to what Mr. Straub was kind of relief he was seeking. There's been no divorce decree entered in this case, correct, Ms. Hills?
That is correct, Your Honor. We had a partial settlement agreement, which is reflected in the transcript that I ordered.
Okay. It appears that Mr. Straub is alleging fraud on the part of Ms. Straub and that she apparently forged his name on tax returns. That's an issue that Mr. Straub can address with the Internal Revenue Service. A partial agreement, I know we have an order that was entered with Ms. Hills from the agreement placed by the record on March 13th. Did that agreement also address sharing of the tax refunds?
It did in a very detailed manner, Your Honor. The motion that Mr. Straub filed, which we feel strongly should be considered frivolous by the court, addressed not only the fact that the tax return had been filed, but a very detailed distribution of that tax return, which favored Mr. Straub. Court asked him if he had any questions, went through the entire usual waiver of counsel, asking him if he had questions or anything else, any confusion about anything that day. He indicated he did not, said a lot of things in the motion to the contrary, but he didn't that day when he was under oath and the court was questioning him. So my client filed the tax return in the way that she's always filed the tax return. We disclosed it at mediation. We disclosed it on the record when putting the partial settlement agreement on. The terms of the distribution, again, were discussed in detail and placed on the record, and he did not say anything at that point in time.
Thank you. The court's not had a chance to review that transcript, but I did review the order. Ava, the court notes that there's continued mediation with Mr. Walker May 1st at 1:30, but their pretrial thereafter. Is that correct?
Yes, Your Honor. And we still have the issues of he's asking for spousal support. He's asking for child support. And the other issue was the value of the equity in the marital home.
Okay. Well, at this point in time, since Mr. Straub failed to appear for his motion, the court will enter an order. It's presented by Ms. LaPrade that denies his motion. First failure to appear.
Your Honor, we are asking for attorney fees. We did have to prepare a response to this motion. I had to talk with my client about it. I had to order the transcript. The transcript alone was approximately $70, $69.70, I believe. I'm asking for $520 in attorney fees for all of the work that I've had to do to prepare for today.
Of course, now received a response, which actually surprised me. So, because normally do file a response. I thought maybe you were not sure with the motion. So I've not seen a response.
I did prepare and file a response, Your Honor.
Typically, your officer drops one off here at the court, so it must be down in the clerk's office. It's not part of the court file yet. I'm not sure when that was filed, but anyway, at this point in time, the court will reserve a request for attorney fees, Ms. Sills. Mr. Pratt, if you could add that to this order, the court reserves the request of Ms. Sills for attorney fees.
Yes, sir.
Certainly, the court's inclined to grant some attorney fees to Ms. Sills for this fair to appear in his own motion, causing you to. Well, strike that. Perhaps it's best if the court address that this morning. Ms. Sills, can you break down your requested amount of what, 500 and
1 hour in the preparation of the response, review of the motion, discussion with my client. I calculated approximately a half hour for this morning. We're at 20 minutes. I always log in a couple of minutes early. $70 for the transcripts. I charge $300 an hour, which I believe is a very reasonable rate in Monroe County currently. And so that totaled, the time totaled $450 and the transcript another 70, which was the 520 total.
All right. Further reconsideration, the court will award attorney fees to Ms. Sills, the amount of $520. You can just add a sentence, Mr. Pratt, that the court orders that Mr. Straub pay to Ms. Sills attorney fees and costs unnecessarily incurred, the amount of $520.
What time frame would the court allow him to pay those?
I'll order that to be paid on or before May 1st.
Thank you.
2024.
All right. We may be filing a show cause as well, Your Honor, relating to violation of the exclusive use order. I would set that. I believe we have a pretrial set for after the mediation. He went to the marital home and retrieved property that he was awarded in the partial settlement agreement that he was attempting to vacate, and then sent me a couple of taunting emails that I couldn't do anything to stop him as well. So that's where we're at with him at this point.
So he entered the home without permission?
He entered the property and retrieved the boat without permission.
Okay. Okay. And maybe best to go ahead and file a motion once appearing on that date, so at least that issue can be addressed at time mediation. He's aware that that's an issue.
Yes, Your Honor. So
after further reconsideration, the court will in fact award attorney fees amount of $520, attorney fees and costs.
Very good.
To be paid on for May 1st, 2024.
Thank you, Your Honor.
All right, that will conclude this matter. You can zoom out.
All right.
Thank you.
Have a good day.
For the record, this matter is before the court on the objections filed by defendant Father Daniel Salenbien to a referee recommend order that he pay and reimburse the plaintiff, I believe, $2,322 in medical and dental expenses for the minor children of the parties. This hearing is being conducted via Zoom. Present is the plaintiff mother, Christine Hazelschwert, if I pronounced that correct, and also the defendant Father Daniel Salenbien is also present. Good morning, everyone.
Good morning.
The two of you have conferred with Ms. Patrick in front of the court this morning, and Ms. Patrick is writing for the following recommendation. The recommendation is that the referee recommend order be adopted but modified. Namely, plaintiff mother should notify defendant father 1 week before any scheduled medical appointments and/or medical tests for the minor children. Plaintiff mother will forward all EOBs or explanation of benefits regarding minor children to the defendant father upon receipt. Further, mother will forward to father all medical bills due on a monthly basis. That is a recommendation. So it just simply modifies the recommendation that Mr. Salenbien pay that amount, which is essentially 50% of the presumably uninsured medical expenses incurred. Ms. Hazelschwert, do you understand the recommendation?
Yes.
Do you have any objection to the court adopting this recommendation?
No, but can I ask a question just for clarification? Is that include like just regular routine orthodontist visits once they've established care?
Why not?
Yes.
What's the harm in
Okay.
in texting
Okay.
Mr. Salvi and let him know he's got an orthodontic appointment?
Okay.
Mr. Salenbien, do you understand the recommendation?
Yes, sir.
Do you have any objection to the court adopting this recommendation?
No, I do not.
Ms. Patrick, will this amount be added then to child support, the arrears is collected?
Yes, Your Honor.
Right. Ms. Hayes, the court will remind you that to be shared joint legal custody, you have an obligation. We addressed this back in July of 2021. We acknowledge vaccinating the children without any input or approval of the father. You need to notify him in advance of all scheduled doctor's appointments, dentist appointments, OB/GYN appointments. Do you understand that?
Yes, and on most cases, he has been made aware. I guess
Not most, but all cases he should be
Right,
made
right.
aware.
I guess my older daughter that drives mostly schedules them and drives herself. So I guess I was, but we can make sure that that communication happens. But all the medical stuff and before they receive their braces, those things absolutely were communicated.
Okay. Well, I mean, don't you, when your doctor, your oldest daughter schedules an appointment, don't you know about it?
Yeah, doctor's appointments, absolutely. I'm just talking about what she would just get
Notify
for her
Mr.
braces.
Salenbien.
Yes.
Notify Mr. Salenbien. All right, Mr. Salenbien, do you have any questions for the court?
No, I do not.
All right, so hopefully this will not be an issue in the future. Orthodontic treatments, are they still ongoing or have they been concluded?
Both of my daughters had their braces removed probably around August. But we do have a 10-year-old that's probably going to need treatment soon.
Okay, and you go back to Dr. LeBeau?
Yes.
Okay. So when that appointment's scheduled, Mr. Salenbien should be informed.
Okay.
All right. Thank you, Ms. Patrick, for your assistance. The court will adopt the recommendation. You both know the copy. Now we'll conclude this hearing.
Thank you, Your Honor.
You're welcome.
Wilson versus Dylan Sams.
For the record, this matter is before the court for the purpose of reviewing parenting time. This matter was brought before the court at the request of Catherine Scott from the front of the court. This hearing is being conducted via Zoom. It appears we have both parties present. The plaintiff's mother, Katrina Wilson, defendant father, Dylan Sams. Good afternoon, both of you.
Good afternoon.
The record, the two of you have conferred this afternoon with Ms. Brower from the front of the court. Ms. Brower provided the court following recommendation that the front of the court printing time recommendation dated February 22nd, 2024 be adopted. Policy of printing time every other weekend, Fridays at 6 until Sunday at 6 p.m. commencing April 12th, 2024, which is a week from this coming weekend. Further, the parties shall exercise holiday parenting time as agreed. If they cannot agree, then the fallback will be the Monroe County Front of the Court holiday schedule, which you can obtain online. That is the recommendation. Ms. Wilson, do you understand the recommendation?
I do.
Do you have any objection to the court adopting the recommendation?
No.
All right. Mr. Sams, do you understand the recommendation?
Yes, Your Honor.
Do you have any objection to the court adopting the recommendation?
No, not at all.
Okay. And of course, Ms. Scott, I presume both of you received a copy of Ms. Scott's recommendation. She indicated that the recommendation that custody continue joint legal with physical to mom and the alternate weekend parenting time. So that means both of you share equally any major decision concerning the welfare of your two children. Whether it's, if in fact, Ms. Wilson, the children have to be taken to the doctors, and there's any medical procedures, treatment, you need to inform father promptly, timely. Understood?
Yes. Correct.
You have to share equal any decision regarding education and religion. And if there's any disagreement, you have to bring it before the court. Do either of you have any questions for the court?
No, Your Honor. No.
I'm not sure what happened. Mr. Sam's back on November, but obviously the referee report indicates that you were very disruptive. And maybe you're upset about something, but I will assure you can accomplish much more. You get much more recognition from the court and the front of the court if, in fact, you simply can maintain your composure. Just a word of advice. All right, if there's nothing further, I'll conclude this matter. You both have a copy of this. Good job, and hopefully things will work well. The children are growing up quickly. Before you know it, they're going to be 18 and be on their own. So you only have a few more years that you both that they're minors. So and make the best of it. There's enough challenges in life. Make good for each other and the children.
Will do.
Great. That will conclude. Mary Rosenthal, good job. Thank you, Ms. Brower.
You're welcome, Your Honor.
For the record, this matter is before the court, and the defendant's respondent's motion to terminate personal protection order entered by this, actually entered by Judge White, this court's absence back on October 13th, 2023. This hearing is being conducted via Zoom. Present is Attorney James Bartlett, representing the petitioner Paul Hinkley II, and presumably that's Mr. Hinkley. With you, Mr. Bartlett, is that correct?
It is, yes, sir.
And also we have the petitioner, Aaron Hinkley. Also, you are Aaron Hinkley, is that correct, ma'am?
Yes, sir.
Okay, good afternoon. Ms. Hinkley, have you received a copy of the petition filed by Mr. Bartlett on behalf of Mr. Hinkley?
Judge, I just received it by subpoena Monday evening at 6:15 p.m.
That is true, Your Honor, and I owe you a proof of service. I'd forgotten that this was by Zoom. I was planning on tendering it to you in person, but yes, my process server did not tag her until the time she just stated on Monday.
Okay. Okay, so you have received a copy of the petition, is that correct, Ms. Hinkley?
Yes, sir. I talked to my attorney yesterday morning, and he told me to ask you if we could do a continuance by chance, since he doesn't have any paperwork. Mr. Keeney, Michael Keeney.
Okay, did you give him the copy of the petition?
Yes, I sent it to him.
Okay, and what, are you saying he was not available for today?
Correct.
Mr. Bartlett, of course, I plan to give her an opportunity to come back to the attorney if that's your choice.
And I mean, I anticipated that request due to the fact that she was served Monday evening. I had warned my client that this might happen. I don't object. I would be, I would not be acting on good conscience if I did it.
Okay. Right, we'll get some new dates here. Just for the court's information, the two of you are divorced, correct? Mr. Hinkley, you're divorced? You have a child in common?
Yes, sir.
How do you currently handle parenting time exchanges?
At his parents' house.
Okay.
Basically at his parents' house.
Okay, so the two of you don't have any contact. You go to his parents' house to pick up and drop off the children, correct?
Correct. I do not. No.
All right. Okay.
That would be the 24th, Wednesday again at 2:30.
2:30. And do you need me to prepare a re-notice, or the fact we're doing this on the record takes care of that?
We need to have something in paper, so if you could do re-notice.
You got it.
Ms. Hinkley should do that, but if you don't mind, Mr. Bartlett.
Not a problem.
All right, so we'll continue this to April 24th. At 2:30. So Ms. Hinkley, make a note of that, April 24th. It's a Wednesday at 2:30. Call Mr. Keeney, because this is where Mr. Barrow's entitled to a timely hearing, so we're not going to adjourn this again. So if he cannot make it, maybe he's got an associate in his office that can assist.
Okay.
So call him this afternoon to get it on his calendar, and don't wait for the piece of paper. We know it's hearing April 24th at 2:30. Where do you want to Mr. Bartlett to mail you this notice of hearing?
At my current address, which is, I can give it to him. The prosecutor's office
please.
has it.
For safety's sake, I'll take it.
Yes.
Okay, this matter is continued to April 24th, 2024, 2:30 p.m. Ms. Brown, if you'd be kind enough to renotice it, that would be much appreciated.
Yes, sir, no problem.
Okay, all right, we'll see you then.
Thank you.
Yes. They've met. The two of them have met.
This is a PPO.
Right, but you've got two attorneys, so the two attorneys conferred. Okay. Yes, yeah, we'll talk. Mr. Bartlett, Mr. Goldman, do you want to confer?
I would like a quick minute, just, and I don't expect it to take very long. I do have Mr. Hinkley with me. I'll just have him excuse himself from the room. Let me just shoot the breeze with the other attorney real quick and see what we can do. Thank you.
Okay, we'll put you in a breakout room then.
Yep, if you don't mind.
Top of page 4, Aaron Hinkley versus Paul Hinkley II.
Oh, that's a long file. For the record, this matter is before the court on the defendant's motion to terminate a personal protection order entered back on October 13th, 2023. This hearing is being conducted via Zoom. Present is Attorney Alex Goldman representing the plaintiff petitioner, Aaron Hinkley. Ms. Hinkley is present. In addition, Attorney James Bartlett is present representing the respondent, Paul Hinkley II. Mr. Hinkley is present with Mr. Bartlett. Good afternoon, everyone.
Good day.
Good afternoon.
So if I may, since it's our motion, I guess I'll try to be as concise as possible in regards to what I believe the agreement is. We had originally filed our motion to terminate this some time ago. Since then, there have been some developments. We are in agreement that the personal protection order remain in place with one modification. Presently, Mr. Hinkley is being directed to use third parties to transport the children for visitation. Ms. Hinkley has, and I'm not bad-mouthing anybody, she's allowed to, she's not the subject of the PPO. She's gone to his home and dropped off the children, etc. So I believe we're in agreement to remove the third-party requirement for transportation for the children and change that to curbside. She lives in an apartment complex. Mr. Hinkley does not have the desire nor need to go to her door. The children are old enough to be to get themselves from the curb to her apartment. So that's the modification that we're all in agreement on.
Thank you, Mr. Bartlett. Mr. Goldman, is that correct?
Yes, Your Honor.
There's also an underlying family court case, is that correct?
Yes, Your Honor. I believe there's a divorce.
Okay, well,
That was a long time ago.
what's the last order in that case provide for transportation of the child for parenting time purposes? Does it also have same language requiring the third party to be utilized?
It did not.
Okay, so there's nothing in that family court case that has to be modified, just simply this provision in paragraph L of this PPO needs to be stricken from this PPO, is that correct?
Yes.
Or maybe modified to specify curbside exchanges. Well,
Either
or maybe
way.
not. You're right, because it's already, he's prevented from entering the property. So maybe
Correct.
it should just be stricken.
Okay, and it's noted that the exchange will be curbside. The child is old enough to get in and out of the vehicle, is that correct?
Yes.
Okay. Of course, the other option is, and I'll leave it to, I don't want to throw a wrench in this. The other option is to simply just terminate the PPO and enter into a mutual restraining order in the DM case with such provision.
That is not our preference, Your Honor.
Agreed.
Would that be cleaner than the DM case? Then it's all in the DM case and we can simply just close out this PPO?
That's not a request, but we do appreciate and take your recommendation or your proposal under advisement.
All right. So you want the court to then, I can print out another order and simply just modify the PPO to eliminate paragraph L requiring third-party transportation, correct?
Yes, sir.
All right.
Yes,
All right, do you want the party sworn? Do you want to ward their respective clients, Mr. Bartlett? Mr.
Sure, might as
Bowman?
well. We're here.
Thank you. All right, Mr. Bartlett, you want to begin with
Sure.
Mr. Hinkley?
So, Mr. Hinkley, I know that you had retained me to help terminate this personal protection order some time ago, correct?
Yes.
All right. Since that time, there have been some developments that at this point, we're not seeking a complete termination, but we are seeking a modification, correct?
Yes.
All right. And you heard the modification terms that were placed on the record today, correct?
Yes.
And those are agreeable to you, correct?
Yes.
All right. Thank you. Nothing further.
Mr. Goldman, any question of Mr. Hinkley?
No, Your Honor.
Questions for Ms. Hinkley?
Yes. Aaron, did we discuss the terms of the modification that were just read on the record?
Yes, we did.
Do you have any questions about that?
No, I don't.
And do you agree to modify the PPO along those terms?
I do agree to modify those.
Nothing further, Your Honor.
Mr. Bartlett, do you have any questions of Ms. Hinkley?
I do not. Thank you.
Very well. The court will enter such an order modifying the personal protection order in this case. Though it's a motion to terminate, we'll modify it to eliminate the requirement that third parties facilitate transportation. The parties shall do so themselves, and simply it'll be a curbside drop off.
Thank you.
All right. Thank you, Mr. Bartlett. Mr. Goldman, for helping facilitate ample resolution that appears most reasonable. The court would applaud Mr. Hinkley for reaching their own agreement. So with that, the parties can zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome. For the record, this matter is before the court for a review of CPS and Taylor Police Department reports regarding an alleged incident involving defendant father and the minor child. This hearing this afternoon is being conducted via Zoom. Present is Attorney Jason Kazmarek, representing the representing the plaintiff mother, Sonia Chavez. Mrs. Chavez is present with Mr. Kazmarek. In addition, the defendant father, Miguel Chavez, is also present. Good afternoon, everyone.
Good afternoon. Good afternoon, Judge.
The parties have confirmed with Ms. Mayville from the front of the court this afternoon, and the court received the following recommendation that pending the outcome of the investigation with the Taylor Police Department and our Wayne County Prosecutor's Office, defendant shall have reasonable supervised parenting time with the minor child in the presence of the plaintiff or any agreed upon third party. Plaintiff's counsel shall be responsible for providing the status of the investigation by the next review dates. The parties agreed to reserve the issue of father's make-up parenting time in the event the outcome is that the defendant father is not being charged with any criminal offense. The initial parenting time order to be practiced. And the matter shall be reviewed on May 22nd, 2024 at 10:30 a.m. I see. In the event the defendant is not charged, then I guess in the interim, that the parenting time previously ordered shall be practiced. The parties will appear back for the court for these matters on May 22nd, 10:30 a.m. That's a recommendation. The court would note, I don't know if Ms. Mayville received a copy of this. The Department of Health and Human Services issued a letter dated March 5, 2024, to whom may concern regarding the investigation of February 12, 2024 of physical injury to Jeremiah Chavez by Miguel. The allegations are unsubstantiated. Currently, this is authored by Megan Anger, Child Protective Services. Currently, I have no concerns for Jeremiah's safety at the home of Mr. Chavez. This case is closed. No further concerns are present. Ms. Mayville, did your office have a copy of that letter?
Yes, Your Honor. Both parties agree that the CPS investigation had been closed and was not substantiated, but there is an issue with the Taylor Police Department not receiving a denial or acceptance of a bench warrant. So the position is that their plaintiff is still fearful for the child's safety at this point.
That's correct, Judge. So I received an email. So I talked to the detective yesterday. The detective DiGiacomo sent me an email stating that he's requested a warrant from the Wayne County prosecutor for Mr. Chavez, which is still pending. It's not been seen by the prosecutor yet, so it's not been approved or denied. He's awaiting that. The detective indicated in the email that he called him a few weeks ago, but hasn't heard back. In fact, he just checked on it apparently very recently, and it still has not been reviewed. So it's still on the prosecutor's desk. I asked the detective how long that usually takes. He said anywhere between 2 weeks and 2 months. So we're waiting for the Wayne County prosecutor to act or not to act.
Mr. Kreisberg, does mom really want to prosecute dad, and she wants that child to testify against her father? I mean, really? I mean, we have a CPS report saying they have no concerns that the child's not in any danger.
I understand, but again, I think whether it's prosecution can involve anger management, things like that. I mean, this isn't the first time there's been allegations against Mr. Chavez. There's similar allegations of abuse back in, I think, 2022. I mean, if there is a prosecution, I don't know if she wants him to go to jail per se, but if that would involve, again, he's in counseling as well. If that would involve some domestic violence counseling, anger management counseling, things like that. Again, the disclosure was made not to my client at all. It was made to the school. The school called CPS, and then there was direction called the Taylor Police to make this report. The child was forensically interviewed by detective. So those details have not been disclosed to my client or myself. But again, she doesn't know what he told the detective, but apparently whatever he told the detective was enough to have him request a warrant from the prosecutor. So there is concerns, and until she gets a copy of the police report, she doesn't know necessarily what Jeremiah said, frankly.
Well,
so yes.
What happened to the days when these things were dealt with within the family? Mr. Chavez, perhaps wants you to engage in an anger management counseling program so that you can show mom that you've gone through some counseling and you're not going to respond in such a fashion as alleged. And then perhaps
absolutely
concerns. The old days, these things were dealt with in family. Why are we going to outside sources and dragging this matter out for months? What are we going to accomplish? So, Mr. Chavez, have you enrolled in any type of anger management or counseling program?
I can do that if that is required. I know I'm innocent of these charges. However, I would do anything in order to have the relationship that I've always maintained, stability, and that we've always had where we were dealing with it inside the family. Also, those prior charges were also unsubstantiated before. However, I will be open to anything because my son tells me he misses me.
You shouldn't have to be directed to do that. Doesn't it just make sense if your parenting time right now is suspended, your son's making an allegation to the school counselor, not the mom, but school counselor? Don't you think you as a parent would take some action to alleviate concerns to make sure that
I will do so. I will do so, Your Honor.
Physically?
Oh, I would not ever do that. However, I would, yes, take whatever classes are recommended. Yes.
Well, it's been recommended taking like an anger management counseling program.
I will do so.
I mean, even if the Wayne County prosecutor charges you, that's really going to reflect what favorably upon you, the fact that you've addressed this thing on your own rather than being forced to do so. Be proactive, Mr. Chavez.
Yes, Your Honor, I will do so.
So it's recommended for the court today that your parenting time be supervised, and then we come back in another 6 weeks. What is your position on that?
If that's all I can get, then yeah, because I was told if there was any way to please Miss Anger, the CPS investigator, was asking me to please ask you if there can be if you can hear because she couldn't be subpoenaed because I didn't have a lawyer. But there's, of course, if there's any way you can reach out. However, I would also, yes, I agree. If the case is not closed, then yes, I do agree to, because to see Jeremiah supervised, I know I'm innocent, but we want to make sure that all parties know that.
Okay, have you had video contact with your son in the three
video contact? Yes, I have been getting. Some weeks I've been getting the 3, and sometimes I get more than that. I
I get at least four days a week, it sounds like. So she's been
How are those
going a
sessions
little
going?
above and beyond.
How are the sessions going with your son?
Very well. My son, of course, very well. I have many screenshots I took in of him kissing the phone, saying he misses me, saying he loves me.
Right, Mr. Kesmerk, does mom agree that the video contact between dad and the son have gone well?
I'll let her explain. She was actually what he was talking. She was explaining that. Go ahead.
For the most part, Jeremiah really enjoys his video contact with dad. There are times when he wants to hang up and dad doesn't want him to hang up right away. He has shown a little bit of just more or less frustration in those moments. Yeah.
So there's also been an in-person visit. I know that Mr. Chavez has come to some church events, seeing Jeremiah, as well as come to my client's home to see Jeremiah. Oh, I'm sorry, he was invited to do that. I don't know if Mr. Chavez showed up at the church events. He did come to plaintiff's home for about an hour. When was that?
Last Saturday.
So
Saturday morning.
Yeah, so last Saturday, yes. So again, I think my client's willing to work with him as far as whatever his work schedule provides. So that was discussion that Mr. Chavez could come to my client's home to visit the child unless they agreed on somebody else, which I think there's going to be some discussions about that. My client does not want to necessarily prevent Jeremiah from seeing his father. Jeremiah has expressed some frustration or anxiety about sleeping at dad's home to both mom and the counselor that he sees. I don't have that in writing, but that's been a concern of Jeremiah's. Don't know why that's a concern, but that's a concern that he's expressed. So that's where we stand.
Mr. Chavez, are you aware? Do you have the name of Jeremiah's counselor?
Yes, and I have reached out to her. I am expecting her phone call. I told her, I gave her my number and my email address. Once she'll be contacting me soon so that I can, because I like to do everything for my son's mental health. And of course, I always safety physically as well.
Okay. Perhaps you want to provide a counselor with a copy of this letter from CPS, but you want to make inquiry to the counselor what you can do to make your son Jeremiah comfortable. And my guess is you're going to say take an anger management counseling program. Maybe she can recommend an agency that does that. So I think the court's strongly encouraging you, I'm not ordering you, I'm strongly encouraging you to enroll in an anger management counseling program.
I will be looking forward today.
Okay, and then make sure you contact with the counselor and inquire the counselor what you can do to alleviate any concerns that Jeremiah may have.
Amen. Yes, Your Honor.
Are you comfortable seeing Jeremiah over at mom's home?
I am comfortable. The only time that I went there, which was Saturday, it was very, very nice because he got to hug me, came and he hugged me multiple times, and we played as we always do. I'm a very interactive father. I would be willing to do that. Hopefully, that as long as me and him are able to have some time where we're safe. And I don't know how it is if somebody's always, staring at us. This kind of makes for something weird, or if it could just be something nice. But it was very, very nice, so I'm comfortable with it. As long as
what about a third party? Have you talked about a third party, maybe an aunt or a sibling that can supervise playtime? It doesn't have to be mom. Could be a third party that you agree upon. Have you talked?
I'm comfortable with mom or anybody that she agrees upon. Anyone, as long as my son can see me.
All right. Well, at this point in time, the court's going to adopt the recommendation, Mr. Kazmarek and Mr. Chavez. For any time, dad's time shall be supervised. Now, again, we're still going to continue the phone contacts, correct?
I would hope so.
Okay.
Video contacts. Of course, we can always do that.
So, do we need to? We'll continue just to make sure everyone understands the video contacts. Saturdays, Sundays, and Tuesdays shall continue as previously ordered, but in addition to the video contacts, there shall be personal contact, but it should be supervised in the presence of either mom or an agreed upon third party. Maybe you can take Jeremiah to a park on a Saturday or Sunday afternoon with the weather getting better, Mr. Chavez. And you can have mom, if mom wants to be there, she can sit in the car. You and Jeremiah can be out in the playground. Or you can, if mom's not available, find a third party that you're both agreed with. And hopefully we'll have some information from the police department. The court would suggest to be proactive, Mr. Chavez, and complete an aggravated counseling program. That will go a long way to make this thing go away. Okay, we'll review this matter then May 22nd at 10:30 a.m. Any questions or anything further, Mr. Kaczmarek, from your standpoint?
Judge, thank you.
All right, Mr. Chavez, do you have any other questions, concerns?
As far as the visitations that I'm able to see him, is there a set? Is there like a limit? Because I heard that she'd be willing to work with whatever I have. Of course, the only days I have off are Saturday and Sunday, and
okay.
But does it matter when?
If she's not available, find a third party.
No, we suggested there's days he gets off around 5:30. So we suggested after work, any days that she's available, which is fine.
But what about a Saturday third party?
In mediation, we already discussed that. I said if there's a Saturday that I don't have a job and we're just at home relaxing, then you're more than welcome to come over.
But what about third party, family member of yours?
Yeah, we can look at that too. I have to speak with family and see who's able to do that for us.
Oh, jeez.
Maybe you have a family member, Mr. Chavez. Do you have a sibling?
All my family members live out of state, Your Honor.
Maybe you have a mutual friend, a former neighbor or something.
Oh, yeah, maybe somebody from church, a church friend, Sonia.
Sure. So
we suggest that's fine.
Anyone that the two we agree upon is acceptable.
Okay.
So come up with some names. If Ms. Chavez is not available on Saturday, Sunday, then propose another party and make sure that person's available to meet you at a park, or we'll see. Obviously, you have to be flexible with that third party schedule as well. So hopefully we'll have some closure on this and we get back to normal parenting time when we come back on May 22nd at 10:30. And again, the court suggests Ms. Chavez reach out to Jeremiah's counselor and also enroll in, perhaps even online, a management counseling program and provide documentation you've completed that.
Yes, Your Honor.
With that, the court will adopt Ms. Mayville's recommendation. Thank you, Ms. Mayville. Now we'll conclude this hearing. You can all zoom out. Have the rest of the day. We'll see you back on May 22nd, 10:30.
Thank you, Your Honor.
For the record, this matter is before the court for the purpose of reviewing parenting time, specifically for the defendant father. This hearing is being conducted via Zoom. Present is Attorney Jason Kaczmarek, representing the plaintiff, Sonia Chavez, who's present with Mr. Kaczmarek in his office. In addition, defendant father Miguel Chavez is also present. Good morning, everyone.
Good morning.
Morning.
Good morning.
Well, the parties have conferred, I believe, with Ms. Patrick from the front of the court, who's provided the court the following recommendation that parenting time shall revert back to the prior order of August 1st, 2023. Actually, it's a recommendation of Ms. LaPrade. I'm sorry. So week 1, father shall have parenting time Thursday at 5 p.m. until Monday at 5 p.m. Week 2, father shall have parenting time Wednesday at 5 p.m. until Friday at 5 p.m. The party shall have 2 weeks uninterrupted, non-consecutive vacation weeks with the minor child. The party beginning parenting time shall be responsible for transportation. Week 1 for father shall begin May 30th, 2024. Which is a week from tomorrow. That is a recommendation. Mr. Kaczmarek, is this recommendation agreeable with your client?
Yes, Judge.
Thank you. The court was previously informed that CPS had closed their investigation. Presumably, Westland Police Department has also closed their investigation.
As of May 16th, that's true, yes.
All right. Okay, good. We can go back to where we were. Mr. Chavez, do you understand the recommendation?
Yes, Your Honor.
And presumably you're agreeable. They go back to the parent time you had before. Is that correct?
Yes.
Wonderful. Mr. Kaczmarek, do you wish to voir dire your client on the record this morning? She obviously participated in the discussions with Ms. LaPrade.
No, thank you, Judge, not needed.
All right, Mr. Chavez, do you have any questions?
None at this time, Your Honor. Thank you.
All right, the court will adopt the recommendation. Thank you, Mr. LaPrade, for your assistance this morning. The court will adopt the recommendation. Thank you, Mr. Kazmarek, for your assistance. And now we'll conclude this hearing. You can all zoom out.
Thank you.
Thank
You're
you.
welcome.